Morning, my lady.
We ready to start?
Yes.
You, please place the matter on record. In the Special Tribunal of South Africa, in the matter between ZAKHELE, EZEKIEL, THABO, LEBELO, and others, in the Special Investigating Unit and others, case number GP 06/2022, before Justice Mudiba, counsel may place themselves on record.
As it pleases you, my lady, I appear for the applicants in the application to stay with my learned friend, Ms. Lipschitz.
Thank you, my lady. I appear in that same application, that stay application for the respondents, the SIU and Transnet, together with my learned friend, Ms. Blizzard.
Thank you.
As the court pleases. My lady, just to recap as to where we are in the proceedings at this stage, there is a rule NISA in place for an interim interdict, and the matter was set down for the confirmation of that interim interdict. The applicants who were the respondents in the main application then brought the application to stay the proceedings and for the interim order not to be confirmed, pending the outcome of two matters which are pending before other courts at the moment. And I will deal with that in a moment. But what will happen, my lady, practically, whether the order is granted today, the rule is confirmed or not, practically, it will make no difference. There will still be a rule in place, either a rule or an interim interdict in place. And if the rule is in place, it is pending the confirmation of the rule, which we say can only be done once those judgments have been handed down. If the rule is confirmed, it will be pending. There will be an interim interdict in place pending the outcome of the main proceedings which have been instituted last week, in fact, my lady. So we say, my lady, that no matter, it doesn't really matter what decision your ladyship makes today or as a result of this application, the practical effect will be that the status ante quo will remain. And that is, my lady, because the applicants in the application for stay have agreed or consented to the rule remaining in place, pending the outcome of those decisions in the Constitutional Court and the other court. So that is the status of the application for the interdict, my lady. As far as the application for a stay is concerned, my lady, we say that because there are these two applications pending. In the one application, my lady, it was an appeal to the Constitutional Court. That's the LEBELO decision or matter. And although we don't know exactly when judgment will be handed down, my lady, the application was, or the appeal was argued in about May this year already, and judgment must either be imminent or is expected probably before the end of this year.
I was actually pleased to see that in your heads. I thought you are privy to information we don't have, because we eagerly are awaiting that judgment.
Yes, my lady. So my lady, I will address your ladyship on what should happen if your ladyship grants the stay application. Till when should we wait? But we say, my lady, no matter what the Constitutional Court decides in that application, it will have a material impact on the present application, and it's not an academic exercise. It will have a practical effect on the present application, my lady, and that is why we say, my lady, that justice requires this application to be stayed pending the outcome of at least the decision by the Constitutional Court in the LEBELO matter. Now, what was argued in the LEBELO matter, my lady, and I know that your ladyship have granted orders or given judgments in the past in this tribunal, especially the Caledon matter that I'm thinking of at the moment, where your ladyship, with this issue of whether the special tribunal is a court or not, was also argued before your ladyship, and your ladyship has found that it is in fact a court. So it is a difficult argument to make before your ladyship, seeing in light of those previous decisions by your ladyship. But, my lady, the fact is that the issue is at present a live issue before the Constitutional Court, and the fact that the Constitutional Court is obviously grappling with that issue shows that there are potentially a probability that the Constitutional Court will find that the special tribunal is not a court. And your ladyship, in the Caledon matter that I've just referred to, referred also to the decision by His Lordship Mr. Justice Vroneman in the Special Investigation Unit versus, I think it was the Nkungwana and another matter, which was reported in 2001, Volume 4 on page 774. It was a decision of the Eastern Cape Division, where His Lordship found that the special tribunal is not a court. So there are conflicts.
I don't know if you've read that judgment, and I make the point in Caledon, that was not the issue before that court.
Yes.
That statement was arbiter.
Yes, your ladyship made the point, exactly, my lady. But
the binding authority is Nadesan, the SCA in Nadesan.
Well, that decision. Yes, my lady, we had a look at that, my lady, but that decision does not say that the special tribunal is a court, with due respect. All it says, my lady, is that it warns about what a special tribunal or a tribunal should do, that a tribunal is limited in certain respects. And then it says that, I think, if I may just get to that quickly, my lady. I think your ladyship referred to that in paragraph 30 of the judgment in the Caledon matter. The SAA held that the tribunal consists of a judge and has in general terms the powers of a high court in relation to matters falling within its terms of reference. Appeals lie against the judgment of the tribunal to the full court or to this court. And on that basis, your ladyship found, and my lady, I'm not going to argue that your ladyship was wrong. Obviously, your ladyship has your views on this matter, and your ladyship has expressed that in the Caledon matter and in other matters. But this was exactly, this formed the basis, my lady, and for the LEBELO argument in the Constitutional Court. And all that we're saying, my lady, is that there is at this stage a probability or a possibility that the Constitutional Court will find that your ladyship was wrong, and that the special tribunal is not a court for purposes of Section 166 of the Constitution. So, my lady,
du Plessis, you
yes.
have benefited from the heads in LEBELO, which you've attached to, I think it's to your heads, right?
Yes.
And I mean, I followed the oral argument in LEBELO.
Yes.
I saw the written heads for the first time when you made them available to me. And it was quite clear from even when it was argued, and it clearly appears from the heads that you've availed to me, that the respondents in LETLA did not deal at all with the Caledon judgment. They didn't address that judgment at all.
No, my lady, but what I'm saying, my lady, is that the reference to the Nadasen matter in your ladyship's judgment does not support the conclusion that the SCA found that the tribunal is a court. All that the SCA said, my lady, was that it has the powers of a high court and appeals lie against the judgment of the tribunal to the full court or to this court. That does not mean, my lady, it does not, the conclusion one can draw from that, with due respect, is not that the SCA said that the tribunal is a court. And what was decided in the LEDLA matter, my lady, by one of your ladyship's colleagues, one of the, I can't remember who the judge was, sorry, my lady?
It was Motley.
Judge Motley, as a court pleases. And he basically decided on either the same basis or on a similar basis. And it was argued before the Constitutional Court. And the fact that the Constitutional Court has taken so long from May this year to give judgment and hasn't handed down that judgment shows, my lady, that at least they are grappling with this issue and may conceivably decide that that your ladyship was wrong, or that Judge Motley was wrong.
Yeah, but we don't know. We cannot conclude from the length it has taken the court to deliver the judgment that they will find for the respondent.
No, of course not, my lady. That's not what I'm saying.
I'm very interested in the prospects of success, you know, of that argument in the Concord, which is not addressed in your heads of argument.
We don't have to address that, with due respect, my lady. All that we have to say, and we're very careful, your ladyship would have noted from our heads that we were very careful not to try and make out a case that your ladyship was wrong in the Caledon matter, or your ladyship was right, or the Concord, or what the Concord will decide. But until the Concord has made a decision, until the Concord has pronounced on this issue, one cannot prejudge this issue by deciding what the Concord will decide. If your ladyship decides, for example, that there is no way or no manner or no basis on which the Constitutional Court can decide that the special tribunal is not is a court, then, my lady, your ladyship would probably would prejudge the issue. And we say there's no basis on which the tribunal can do that at this stage. We say we should wait until the Constitutional Court has made their decision and until the Constitutional Court has pronounced on this issue. And that is why the fact that the respondents, my learned friends, have addressed this issue in their heads, that is premature, because they would want your ladyship, it seems, to make a decision and to make a pronouncement.
They've actually not addressed it. That's not how I read their heads. In their heads, they're saying the tribunal does not have to be a court. And they're making a different point. They're saying it doesn't have to be a court.
We'll deal with that in a second, my lady. But what they want, that was also one of the reasons, one of the issues that were addressed before the Constitutional Court, because the whole issue of whether the special tribunal has the authority to grant forfeiture orders was formed the basis of the argument before the Constitutional Court. And that is the second point, obviously, on which we rely. We say it follows, if the special tribunal is not a court, that the special tribunal is then bound to the confines of the Act, of the four corners of the Act, and cannot then rely on the rules and the regulation issued in terms of the Act that granted it, or that purports to grant it, more powers than what it was given by in the Act. What the respondents rely on, my lady, to say that the special tribunal has the power to grant a forfeiture order is Section 8.2 of the Act. That is the high water mark of their case. And they say it's Section 8.2b which says that it includes the power to make any order which it deems appropriate so as to give effect to any ruling or decision given or made by it. And my lady, that argument was also formed the basis of the argument in the Constitutional Court, and also cannot be prejudged at this stage. We say, my lady, that what that means, that's a reference, my lady, to what came before it, which was to issue suspension orders, interlocutory orders, or interdicts on application by such unit or party, because that's the power that the Act provides to the.
Lost Mr. Du Plessis. I don't know whether it's me. Okay.
My lady, can your ladyship hear me, my lady?
I think we have lost the judge. Yes, she will just reconnect shortly.
All right,
Thank you. Thanks.
I'm back, Mr. Du Plessis.
As the court pleases. My lady, we say that Section 8.2, which is the high watermark of the respondent's case for the argument that the special tribunal has the authority to grant forfeiture orders, even though it may not be a court, is not authority for that proposition, because Section 8.2 only talks about orders which it deems appropriate so as to give effect to any ruling or decision given or made by it. And that ruling or decision must refer, my lady, to Section 8.2a, which are the issuing of suspension orders, interlocutory orders, or interdicts on application by such unit or party. It cannot be extended. One cannot read into that it also has the power to grant forfeiture orders.
Let's look at that argument hypothetically.
Yes.
Section 8.2 does not expressly give the tribunal the power to grant orders in respect of a monetary order. Doesn't mean this tribunal cannot do that. It's very clear from the ambit of the Act that the tribunal, the primary jurisdiction of the tribunal, is to grant orders relating to the recovery of monies lost to the state.
Yes.
Those orders are granted by the tribunal. The tribunal's powers to grant those orders has never been challenged. In fact, the relief that the applicants seek in the review application, application that was instituted last week, the main relief is monetary in nature.
Yes.
The respondents are not challenging that relief. Now, the forfeiture relief is only consequential. If I find no liability on the part of the respondents, the question of forfeiture doesn't arise at all.
Yes.
Doesn't arise at all. So the main relief is not being impugned.
Yes.
And I have difficulty with finding that it is in the interests of justice to delay accountability, particularly by Lebelo and Mashamba, who were state functionaries who had fiduciary responsibilities towards the state. They had no right to profit from the employment relationship. The allegation against them is that they did, and they are delaying answering to those serious allegations against them. They are delaying a monetary judgment against them in the event that it's established. That's the effect of the relief you are now seeking. All of that should wait because they have difficulty with the consequential relief that may be granted in the event that a monetary judgment is granted against them. How can
No.
that be in the interest of justice?
Larry, let me just make it very clear that this application that we're dealing with at the moment is for a stay of the preservation order, of the interdict, which is basically the preservation order. In other words, the confirmation of the rule. That's what this application is about. The main application that Your Ladyship is talking about was only launched last week, as Your Ladyship quite correctly pointed out. Whether we will ask, whether the respondents will ask for that application to be stayed that's not before Your Ladyship at the moment, my lady. So we're not at this stage trying to postpone the main application. In fact, my lady, the main application, there will be a proper answer on the merits. Because they won't have an option but to do that. And Your Ladyship mustn't, there's no basis, my lady, with due respect, to say that the present applicants are also asking for a stay of the main application. I know that my learned friends in their heads said that the applicants wanted to increase the ambit of the relief that they're seeking because there was a sentence in our heads of argument which referred to the main proceedings, but that is not so, my lady. This application merely deals with the interim interdict and with the confirmation of the rule. And my lady, the protection afforded to the respondents in the stay application, the SIU and the other respondents, are there. It remains there. There is no...
I have difficulty with understanding the purpose of this application. The rule nice is in place. It's effective from the date was granted.
Yes.
And your clients have no difficulty with that order remaining in place until the review application is determined.
No, my lady. Until we don't have a problem with that order remaining in place until the decisions of the LEBELO and the other matter. Because, my lady, the issue is this. If the Constitutional Court, for example, decides and finds that the tribunal does not have the power to grant a forfeiture order, then we say, then the argument will be that one of the requirements for an interim interdict is that the balance of convenience must favor the applicant. We will then say, my lady, if the applicant cannot succeed with the main relief being the forfeiture order, then it will have an impact on whether the tribunal should then confirm the order, confirm the rule. And that's why, that's the practical effect of the application for a stay, my lady. Otherwise, other than that, my lady, it will have no practical effect whatsoever because, as your ladyship quite correctly points out, the interim order, or the rule NISA at least, remains in place until we know what the Constitutional Court has decided. And once we know what the Constitutional Court has decided, I mean, then the parties can look at the rights and their positions in law, their legal positions, and can decide whether they want to rely on that or not. If the Constitutional Court decides the issue, obviously against the LEBELO, the applicant or the appellant in that matter, that's the end of the matter, my lady, because then the court has spoken. And then the tribunal will have that power and nobody can say anything about it. But that's the practical effect of this application, my lady. We say, and your ladyship must remember that the rules provide that one of the prerequisites of a forfeiture order is that there must be a preservation order in place. That's what the rule says. So that also will have an impact on the final relief. If the tribunal does not have the power to grant a forfeiture order, well, then the SIU, if it wants such an order, will have to go to the High Court. And we will face whatever difficulties we have in that court, my lady. But we say, my lady, that these issues these issues are currently pending before the Constitutional Court, and the tribunal, we say, must stay these proceedings until the Constitutional Court has decided on these issues. And as far as the other matter is concerned, I know that my learned friends have criticized the application because that's an open-ended, we don't know when that application will be heard. It's an application in the High Court where the relevant regulation and
the
rule... The
tribunal does not have to wait with respect
no,
for
of course.
judgment to come out.
Yes. But that the proposal that we wanted to make, or although the application, the stay application says that we must wait for that, my lady, we submit that the LEBELO decision is in fact the one that we should wait for.
The tribunal has held that it is a court with the status of the High Court in terms of Section 166E. So it's
Yes.
a parallel. It stands parallel to the High Court. It doesn't have to wait the other Transnet decision.
Yes. Well, that may be so, as it pleases. But my lady, I again just want to reiterate that that the issue of whether the tribunal is a court with the same powers as the High Court is an issue pending before the Constitutional Court at the moment.
But Mr. Du Plessis, you know, unfortunately, corruption and maladministration has become so endemic.
Yes.
And the scheme of the SIU Act, you know, is couched to address that.
Yes.
We're visionaries, because none of us thought when that act was promulgated in 1996 that we'd be sitting with the kind of endemic problem that we're sitting with today. How can it be in the interests of justice that, because there's that one challenge in LEBELO that is before the Constitutional Court, the tribunal must, because the order that you are seeking has far-reaching implications in a lot of other matters where, you know, relating to loss or potential loss of state monies, right? So effectively, if I find in your favor, effectively the tribunal will have to stop granting preservation orders. How can that be in the interest of justice? Now, even if the Constitutional Court finds that the tribunal does not have forfeiture powers, how can it be in the interest of justice that the tribunal effectively, pending that decision, stops granting those orders? How can that be in the interest of justice, knowing that money is liquid, disappears very quickly? These preservation orders have actually been very instrumental in ensuring that, you know, the efforts of the SIU in chasing money that was unlawfully lost by the state is recovered. How can that be in the interest of justice that I grant such an order?
Well, my lady, the interest of justice obviously will play a role if there is any doubt as to the legal position. We say the legal position at this stage, my lady, is quite clear, and that is that the Act does not make provision for forfeiture orders to be granted. And we say, my lady, and sorry, just before I continue, His Lordship Mr. Justice Fruneman in that matter said in the first, I think the second paragraph of that judgment, he says the Act has a laudable aim, and we agree with that, my lady. We don't say obviously that that there's something wrong with the Act, or that the Act shouldn't have been promulgated. We are attacking certain powers that the tribunal, we say, has taken upon itself, which we say is not justified in terms of the underlying Act and the Act that actually established the tribunal.
The attack to the forfeiture powers of the tribunal is one that these respondents, your clients, I mean,
yes,
should properly raise as a defense in the main application.
Yes.
Because that's where that relief is sought.
Well, my lady, but it also will have an effect on the confirmation of the rule. And I've said that because one of the requirements for an interim interdict, my lady, is the balance of convenience. And one of the tests for the balance of convenience is the prospects of success by the applicant for the interim interdict in the main proceedings, in obtaining the main relief. If the
Yes, the prospects of success cannot be looked apart from the main relief, cannot be looked at apart from the main relief that the applicants are seeking in the review application, which is the disgorgement relief. Now,
Yes.
Are you saying if they succeed in obtaining a monetary judgment against your clients, even if the Constitutional Court has found that the tribunal does not have forfeiture powers, there is no basis for them to execute against the preserved property? Is that what you're saying? That's why I'm saying this argument really belongs in those subsequent proceedings, not here.
Yeah, my lady, there's a difference between execution on assets of a debtor and a forfeiture. A forfeiture means that you've basically already executed. And that is why in the second matter that we refer to, my lady, the matter that's before the High Court, in that matter they refer to the rights of any owner of an asset there can be no unjust or unjustified impact on those rights. And a forfeiture, sorry, my lady.
So that's exactly why I'm raising the issue of the main relief, the monetary relief.
Yes.
So that is the basis for the forfeiture. That is the basis for the execution. But
my lady, if there's a creditor and a debtor, for example, let's look at any normal action in the High Court or before the tribunal. Obviously, a creditor can obtain a money judgment against a debtor if the debtor doesn't have a defense, a proper defense. It does not necessarily mean that the creditor has the right to protect the assets. In other words, for an anti-dissipation interdict over the assets pending the outcome of those proceedings, firstly, and secondly, that once it obtains the judgment, that the assets of the debtor be forfeited to the creditor. Because that's in effect what we're fighting about here. That is the argument. It's about the assets. It's not about, at the moment, about the money judgment. Even if the applicants in the stay application don't have a proper defense in the main application, my lady, obviously then the SIU and the other respondents will have the right to a money judgment and for the disgorgement of the profits and all the rest of it.
This argument belongs there. It's a defense there against the forfeiture relief.
No, my lady. Well, it may also form a basis for an argument in the main application, but it's also applicable in this application, my lady, because of the facts that I've already mentioned, my lady. One of the requirements for the forfeiture, why would the applicant or the respondents in this application be entitled to a preservation of the assets, for example, if they are not entitled to a forfeiture at the end of the day of those assets, even if they do get a judgment? The judgment is something totally separate, my lady. Why should they be placed in a better position if the Act doesn't provide for that? And your ladyship will remember that in the Prevention of Organised Crime Act, the POCA Act, in that Act, the Act specifically and expressly provides for substantive powers of civil forfeiture of assets. And there must be a reason why the legislature in this Act did not provide for that.
And the legislature here has given the tribunal very wide powers to give effect to any order it makes, any finding it makes.
Yes, but to give an effect to an order does not necessarily mean
But isn't that
an order for the forfeiture.
Isn't that what the purpose of a forfeiture is? If there's a monetary judgment, if a finding is made that Lebelo and Mashamba and the other respondents in the review application or in the disgorgement application benefited from the secret profits that Mashamba and Lebelo derived from their employment with Transnet. Is a forfeiture relief not consequent upon that finding that they should not retain the property that they acquired using secret profits? It flows directly from the powers of the tribunal in terms of the Act.
Right. Well, Lady, I've two answers. The first is personally, obviously, I hope that if the allegations are correct, that that the applicants should pay their dues, obviously. But that's why we say the Act has a laudable aim. But this issue, my lady, that your ladyship is just mentioning, is an issue that is now pending before the Constitutional Court. It's one of the issues that was argued before the Constitutional Court, whether the tribunal has the power to grant a forfeiture order. And your ladyship and I can debate this issue for hours on end. It will not take it any further than to wait for the Constitutional Court to finally make that decision. And
I don't know what the Constitutional Court is going to make of the distinguishing factor in the two matters. Remember, none of the respondents in Ledla were employed by the state. None of them allegedly profited from the employment relationship. That was a pure legality review of a tender that was allegedly unlawfully awarded. And in terms of the Constitution, the remedy lies in Section 1721B. So I don't know what the Constitutional Court is going to make of that distinguishing factor.
Yes, I don't either, my lady, and that's exactly the reason.
That is why your balance of convenience argument does actually not favor your client. It does not favor your client. As you say, the rulemaking is in place. It will remain in place on your case until the Ledla decision,
yes.
Right? We don't know when that decision is coming out. The main disgorgement application has now been instituted.
Yes.
I will, as I've indicated, I will have a case management meeting with you at the end of this hearing to determine the conduct of that application.
Yes.
Why should the balance of convenience favor your client, given that that application has already been instituted? There's a very strong prima facie case that is made against your client, which they are yet to answer to. So why should I find that the balance of convenience favor them?
My lady, at this stage where we ask for a stay of the application for the confirmation of the rule, the balance of convenience doesn't play a role. The interest of justice plays a role, but the balance of convenience will play a role when we...
You've raised that issue. That's why I'm dealing with it.
No, I raised it to say, my lady, that if the Ledla judgment in the Constitutional Court is in our favor, in other words, says that the tribunal does not have that power, then the balance of convenience argument will be raised in opposition to a confirmation of the rule. But at this stage, where there is a rule in place and the rule will be extended, that's all we're asking at this stage, basically. We're asking for the rule to be extended until we know what the Ledla judgment says. Then, in this instance, the balance of convenience doesn't play a role. But, my lady, I can't do any better than to say that there are good reasons to wait for the Constitutional Court to determine these issues and to make a decision. In the interim, pending the LEBELO decision, my lady, the SIU and the other respondents will not be in any worse a position than if your ladyship confirms the rule today, because they will still have the protection of the rule that will remain in place. And that is on that basis that we say that the interest of justice requires that the application be stayed until we know what the legal position is. As far, I just want to quickly address the issue of costs, my lady. The respondents have, in their heads, stated that this constitutes an abuse of the process and that that cost should be on a punitive scale. My lady, any litigant is entitled to take legal points, legal issues, to raise legal issues. This is an issue that is alive, that is pending before the Constitutional Court, that was properly argued before the Constitutional Court, and the applicants in the stay application were entitled to rely on that in order to ask for the stay. They are not mala fide, my lady. They, in fact, the fact that they consented in final determination. Sorry, my lady.
But I had lost you, but I'm back. Thank you.
No, sorry, my lady. There was a concession, my lady, that the rule remain in place until the final determination of the LEBELO matter, and that shows, my lady, that this is not a mala fide attempt to inverted commas or to kick for touch. The main application, as your ladyship pointed out, we will deal with that when we do the case management meeting. But that application, in all probability, they will, not in all probability, they will have to answer on the merits. And the merits will be addressed. And my instructions are to place this on record, my lady, that there will be a proper answer on the merits of the application. So this is not an attempt to dodge an answering on the merits of the allegations made against the applicants in the stay application. It's just, my lady, that we say there is a good prospect. Well, it may be good, it doesn't matter whether it's good or bad, but there is a prospect that the Constitutional Court may make certain findings which will have an impact on whether the rule in this matter should be confirmed. And the applicants were quite entitled to raise those issues as a point in limine or as in an application for stay. And for those reasons, and because that application or that judgment is still pending, my lady, and may be in favour of the applicants in this application, your ladyship, in fact, cannot make a cost order at this stage, because if the applicants, if the Constitutional Court finds that the tribunal is not a court and does not have the power to grant a forfeiture order, then the applicants were quite entitled to have launched this application and would have been successful with this application. So, my lady, we say that your ladyship should grant a stay, that the rule NASA should remain in place until the LEBELO decision, and that we should reconvene once the LEBELO decision has become public, my lady. And that the costs of this application should be costs in the cause, my lady. As a court, please.
There's also a very high probability, Mr. Du Plessis, that the Constitutional Court may elect not to touch the forfeiture argument. Yes. And in fact, Mr. Ngukaitobi appeared before me in CMI infrastructures. And you probably are aware that those proceedings in the tribunal have been stayed, but it was by agreement. Yes. The SIU, for reasons known to it, consented to a stay of the proceedings before the tribunal, pending the outcome of a challenge to the tribunal's powers before the High Court.
I wasn't aware of that, my lady.
Yes, and he specifically said to me that the reason why that point is raised in CMI is that it is highly probable that the Constitutional Court may not entertain the forfeiture point because it was raised late. And in its wisdom, I hope the Constitutional Court does not do that, because it will highly benefit from judgments of the tribunal. The tribunal is daily seized with these matters and is steeped in them. And if these issues are raised early, the Constitutional Court will no doubt benefit not only from the arguments raised, but they become refined as judgments are handed down, by the courts in the hierarchy. So it's highly likely that the Constitutional Court may decide not to deal with the forfeiture point at all.
Well, as it pleases you, my lady. It may be so, it may not be so. We just don't know at this stage. But that makes it that much more reasonable for the applicants to ask that it be stayed until we know what the Constitutional Court has decided. If they decide not to deal with the issue, I mean, obviously then that issue will have to be decided by your ladyship. So what will happen, my lady, what we foresee, what we envisage, is that we wait the LEBELO decision. After that decision, we reconvene and we make the submissions that we need to make. Both parties and your ladyship must then take the decision whether the rule should be confirmed or not. And that's the application before your ladyship at the moment, my lady.
Thank you.
Thank you, my lady. My learned friend accepts that the test for the stay application is a question of the interests of justice. And we submit with respect that this entire application is a perversion of the interests of justice. My lady, we say so for a number of reasons. But before I get to the heart of my argument, I'd like to pick up on one or two submissions that my learned friend made, which I submit will evidence that perversion without doubt. My learned friend's central submission is that this court, this tribunal, may not prejudge an issue by confirming a rule nisi in these proceedings, despite the fact that there is not a single fact that is disputed in the voluminous founding papers in the interim interdict application by the respondents, and simply because a question is awaiting determination by the Constitutional Court. My lady, with respect, if that argument was right, it would mean every court in this land cannot give the judgments it is called upon and they are called upon to give, just because some higher court somewhere is going to determine a question of law, which may, after it has determined it, change the legal landscape or make certain judgments that were given prior to the handing down of that judgment wrong. My lady, that could never be a competent legal submission, nor we submit would it ever be in the interest of justice to stay the administration of justice because some courts are tackling some legal questions. My lady, the second submission that my learned friend made, which I'd like to highlight at the outset, is he said on 2 occasions that his clients are going to answer the merits of the main proceedings. He went as far on the last occasion to say that he's instructed to place it on record that they will do so. Well, my lady, if that is so, then this stay application is nothing short of an abuse. The averments in the main proceedings are no less, but are more than the averments in the interim interdict application. In their wisdom, the respondents in the interim interdict application have decided to say they won't plead over. They won't tell this tribunal what their case on the merits is. They want that case stayed, but they recognize that in the main proceedings that were launched last week, they will come on record and they will give this tribunal their full version on the facts. They also seem to not appreciate with respect that the place where forfeiture is sought, if the tribunal ever gets there, is in the main proceedings. But my learned friend has told you this morning, they have no difficulty answering that case on the merits. Well, my lady, if that is so, there is absolutely no basis for this tribunal to stay the interim interdict application. That application has been fully ventilated in the papers. The respondents were given ample time, 6 weeks, to answer it on the merits, and they elected not to say a word about its merits, but to say to this tribunal that because matters are pending in 2 other courts, it must stop its work in its tracks. Work, we say, my lady, you will have seen our argument, that has huge implications for the other matters before the tribunal in which preservation orders are sought. Because, to quote my learned friend, this tribunal can't prejudge an issue. My lady, on the contrary, this tribunal is statutorily obligated to administer justice and to do so expeditiously. The Act specifically requires that of this tribunal. Why? Because its purpose is so important. Its purpose is to bring back to the state what was unlawfully extracted from it by unlawful deeds of corruption, maladministration, and malfeasance. If my learned friend's argument is right, the tribunal must close its doors tomorrow, must not entertain any preservation application, because maybe his argument is now reduced. Remember, it was CMI and it was Ledler. Now it's just Ledler. Because in the Constitutional Court's wisdom in Ledler, they may at some point say something about forfeiture powers. My lady, there's no current order from this court in this case forfeiting any property. There are orders from this tribunal in this case preserving property. And we will address you in a moment why that is a power that was exercised entirely lawfully and within the 4 corners of the SIU Act. But the point at the outset, my lady, is that this application is an abuse. It's an abuse because my learned friend actually reveals the conflicted stance of his clients when he makes his argument before you this morning. They say you can't prejudge, but they know you are a tribunal that is required to exercise its powers and to do so expeditiously. My lady, you even challenged with respect, my learned friend, on where he says the balance of convenience lies. And as soon as you raise that question with my learned friend, he retreats and says, but I'm not here to argue balance of convenience, despite the fact that he highlights the case in the SCA that says balance of convenience can be determinative in interim interdict applications. My lady, with respect, my learned friend's clients cannot have their cake and eat it. Either they want to come before this tribunal and argue before this tribunal that it has no powers to grant preservation orders. If that is their argument, they should have come and made it. They should have pleaded over and they should have said that the rule should be discharged because it would amount to an exercise of powers that this tribunal does not have. But they are coy with respect. They know that that is an argument they will not win. And so instead they use the looser test of interest of justice. They throw in words like prejudging and they say this tribunal must stop its work in its tracks. We say that that, with respect, should not be countenanced by this tribunal. The rule should be confirmed. There is no basis on the merits of this case not to confirm it. My lady, if I may then just move to the meat of the argument for why we in fact say there are powers of this tribunal to grant the very orders that it granted on the 8th of August in relation to the Rule Nisi order. My lady, you will have seen our argument. My learned friend is right. It does proceed from Section 8 of the SIU Act, as it must, because this is a tribunal established by statute, and the powers it exercises must be found in that statute. And we say the language that the legislature chose in Section 8 is indicative of the breadth of this tribunal's powers. The legislature had many ways to craft that section. It knew that Poker spoke specifically about different types of orders. It knew that the purpose of the tribunal, my lady, as you with respect indicated this morning, was principally concerned with recovery. It could have listed monetary awards, forfeiture awards, preservation awards. It didn't do that. It instead chose language of the widest import. It gave jurisdiction to this tribunal to adjudicate any civil proceedings. And then later in the section, vested this tribunal with the power to make any order in relation to its decisions and rulings. Now, my lady, that is language of the widest import. The English language does not admit of a word broader than any. At least we've tried to consider and we haven't found one. Now, my learned friend's argument amounts to the following. Despite the fact that the legislature chose those words of the widest import, we actually have to read that section to mean any civil proceedings, probably in brackets, except proceedings for civil forfeiture and preservation of property. Or, later in the section, may make any order except an order for the forfeiture of property. My lady, that language is not there. It's not there because the legislature chose language of the widest import. My lady, my argument should not be understood to say anything goes. The any in section 8 will be properly interpreted and restrained in its meaning by the purpose pursued by the Act. The Constitutional Court has told us repeatedly that when we are interpreting legislative instruments, context and purpose is everything. So it is not the case, my lady, that any order or any civil proceedings before this tribunal would include, for example, a divorce order or an order compelling a firm to pay a fine for anti-competitive conduct. We can all easily say that any order does not include those. Why? Because they are not instrumental in fulfilling the purpose of the special tribunal. But what types of orders are instrumental? Are preservation orders because of the liquidity of money, because of the need to freeze assets so that they do not diminish in value in order to ensure proper recovery to the state, and forfeiture orders, so that those who would think to engage in unlawful conduct in state institutions are discouraged from doing so, because they know if they are found out, their property will be forfeited to the state. My lady, that spectrum of orders is critically and quintessentially fulfilling the purpose for which this tribunal was established. And my lady, you will have looked in vain in my learned friend's heads of argument or listened in vain this morning for any grappling with the purpose of the Act. What my learned friend cannot submit, I submit with respect because he would not make an incompetent submission, is that there's some purpose of this Act that is pursued by reading any order to exclude forfeiture or preservation orders. He can't make that argument, so he doesn't make it. Their entire case is devoid of any attention to the context and purpose for which this tribunal was established. And we say that context and purpose answers the interpretive question. The legislature could have done it differently. It chose not to. It chose words of the widest import, and it knew that it would be read together with the underlying purpose of the Act. So, my lady, we say on the big legal question, which is, we say, prematurely anticipated in this stay application, but we don't want to shirk from dealing with it because it is of significance to this tribunal. We say that the applicants for the stay are entirely wrong, that the proper interpretation of the Act includes forfeiture powers as well as preservation powers. And of course, we remind ourselves that the only order that this tribunal has currently granted is a preservation order. My lady, if I may just say one last thing on that. My lady, you had a debate with my learned friend about whether preservation necessarily must lead to forfeiture or whether it can be an instrument to execution. We say it can be either. The sufficiency question under the rules is only a sufficiency question insofar as forfeiture is concerned. You cannot get forfeiture as the SIU unless you have a preservation order in place. But the reverse does not operate. This tribunal can preserve property to retain its value, can appoint curators for that purpose similarly, so that the value is retained at the time of execution. And my lady, with respect, that is why it is important to see those main proceedings in their full remit. They are principally concerned with disgorgement of profits, recovery of losses, and tacked onto that, in addition, will be a claim for forfeiture. We don't shy away from that. But to frame the main proceedings as pursuing only forfeiture would be a mischaracterization of them entirely. My lady, the next aspect I'd like to deal with is the one of this tribunal's duty. I have highlighted it in my introductory submissions, and you would have seen it in our heads of argument. Section 9.3 talks about this tribunal's power to act expeditiously and in a cost-effective manner in the manner in which it manages its role in the cases that come before it. We say that that is a duty placed on this tribunal, as our courts have recognized duties may be placed on other functionaries within the constitutional scheme. Powers are sometimes given coupled with duties, and we say this is just such a case. The purpose for which the Special Investigating Unit and the tribunal were established would be undermined if, on the say-so of a set of applicants who don't want to answer the merits of their case because some other matter in some other court is pending adjudication, could then seek from this tribunal a halt to its processes, we say would be an undermining of that duty, which ought to be embraced as this tribunal has embraced it. My lady, the final aspect on the merits is just to consider the comparative positions of prejudice. My lady, my learned friend's argument on prejudice with respect is difficult to follow. On the one hand, the applicants for the stay say those preservation orders can stay in place. The curator can continue to oversee our property. The pension of Mr. LEBELO can continue to be interdicted from being paid out. So actually, they say the very thing that they say this tribunal doesn't have the power to grant as an order can continue to operate against them. Well, if that is so, they bring no claim for prejudice before this tribunal. There's no reason not to confirm the rule then, because they have no difficulty with those orders operating. On the flip side, we say the prejudice both to the SIU and Transnet, as well as to this tribunal generally, is serious if the stay were to be granted. The stay should not be granted because it will keep alive, in a strange way, an interim interdict application in these proceedings pending the resolution in the LEBELO case, so that the SIU and Transnet will have to come back before this tribunal at all the cost, at all the commitment of resources that will require of them, to argue again in due course the merits of the interim interdict application. Those are costs, time and resources that we submit constitute prejudice and should not be required of those two entities who have prosecuted their interim interdict application fully before the tribunal. And my lady, we say that there is the second very real prejudice that, with respect, my lady, you engaged my learned friend on this morning. If this argument is good, it means this tribunal can't issue new preservation orders pending the LEBELO decision, and it means this tribunal must stay all pending other cases where preservation orders are sought. Because why? My learned friend's argument is to take another step in those cases is to prejudge the outcome in LEBELO. And my lady, for all the reasons I've already submitted, we say that that is not a correct approach to the law. Tribunals and courts must exercise the jurisdiction they have. They must do so with consideration to the issues, but that another court somewhere is dealing with an issue does not mean that they halt their processes. My lady, on the question of costs, we say that the stay application should be dismissed. The rule nisi should be confirmed, and both of those should take place with costs. We say that the SIU and Transnet are entitled to the costs of the interim interdict application for two main reasons. The first is that there's no defence to that application on the merits. That is quintessentially a case of substantial success. And the second reason we say is that The route that was used, a rule nisi on notice followed by interim interdict application hearing, was necessary because of the full suite of the relief that was sought. The relief included the interdict against the payout of Mr. Lebelo's pension. That was not relief that the rules of this tribunal permit the SIU or Transnet to bring ex parte. And so for that relief, there had to be notice. And so the full case was brought on notice. There was absolutely no prejudice to the respondents. They've had 2 chances to answer that case. And at no stage have they seen fit to tell us why the compelling case of bribery, corruption, self-enrichment is not an overwhelming case meriting preservation of their property until the full proceedings are determined, holding back on the payment of pension to Mr. Lebelo, and a curator to ensure that the value of that property is not diminished in the interim. My lady, if I may just take a moment to check in with my team. I'm not with them, but they will message me now if there's any aspect that they believe I should also traverse. And while I'm doing that, I just would like, if I may take a moment just to check my notes that there wasn't something I missed in the address. My learned friend, I beg your pardon, my lady, the only point is that we say that those costs should be costs on the punitive scale in relation to the stay application. I've addressed your ladyship at the outset of my submissions why this case is nothing short of an abuse. It is an abuse because it is a tactic designed to hold over for the respondents the need to answer the interim interdict case on the merits. That is its only purpose for the reasons that I've described, because they've said they don't mind that the orders operate against them. They've said they want that pending a position when the LEBELO decision is handed down, but then today they add, and my learned friend said he was instructed to place on record, they'll answer the merits of the case in the main application. Milady, the combined effect of those propositions is that the stay application was brought as a technique to delay for some longer period the respondents' need to answer the compelling case against them. And we say that that is a misuse of this tribunal's processes. So we would move for punitive costs in relation to the stay.
And what about the costs? Remember, if they fail on the stay, then the rule nisi stands to be confirmed. The cost of that application also stood over.
Yes, my lady.
But why should I not reserve those costs?
Well, my lady.
The main application.
My lady, simply for...
There are many main applications here. The application brought last week.
My lady, I have one submission on that. The reason to grant costs on the interim relief application is because there is no answer to it. They may, in other words, the question in the interim relief application is, was there reason to preserve property? Not will Transnet and the SIU in the end be able to show that Mr. Lebelo and Mr. Mashamba engaged in the misdeeds that they are alleged to have engaged in. It was, should their property be preserved? Should a curator be appointed to ensure its value is retained? And should the pension payout be interdicted? Those were the questions before the tribunal in the interim relief application. We say overwhelmingly, we have shown that those orders were necessary. There is no opposition, not a word from the respondents as to why those interim orders ought not to have been granted. And we say the consequence should flow at the level of costs. Transnet and the SIU should then be entitled to the costs of that application. The questions in the further proceedings that were launched last week will be questions that, if vindicated, if Mr. Lebelo and Mr. Mashamba are vindicated, that relief will not be granted and they will get their costs there. But they have made no showing for why the interim relief should not have been granted when it was sought.
Thank you.
Thank you, my lady.
Mr. Du Plessis.
As it pleases you, my lady. Just on the first issue that my learned friend raised, and that is that the prejudging, she said that we shouldn't ask your ladyship not to prejudge the issue that's pending before the Constitutional Court. Lady, I submit that where one deals with a legal question that is, for example, pending before the Supreme Court of Appeal or before the Constitutional Court, as in this case, and you know that that issue will have a material impact on the case that you have before the High Court, for example, and that judgment in that matter is imminent or, you know, is expected reasonably soon. There's nothing wrong by the parties then either agreeing to a stay of the present proceedings because it will have such a material impact, or by one of the parties then launching an application to stay the proceedings, as the applicants did in this case. There's absolutely nothing wrong with that kind of procedure. And your ladyship has indicated that in the other matter, the parties in fact agreed that the proceedings be stayed. So
I had great difficulty with that agreement. In fact, it didn't serve before me. I case managed the issue. So
yes.
When they reached that agreement, it was not before me.
Well,
I don't know what I would have done if
yes.
they persisted with that, because
yes,
these matters are in the public interest. I probably would not have granted that order. In fact, I had directed the SIU to bring a formal stay application.
Yes.
And I can't remember what position they took, but ultimately, when the order by consent served before the tribunal, I wasn't the presiding judge.
Yes. Well, be that as it may, my lady, the point just is that there's nothing untoward about an application to stay pending a decision that would impact on the present proceedings. And my learned friend's argument that your ladyship should just go ahead and close your eyes as to what is happening in the Constitutional Court and the judgment that is awaited there, I just don't understand that, my lady.
But that's what we've been doing, Mr. Du Plessis. I mean, as a presider, yes. I've had to apply my mind to what the pending decision in the Concord means for the continued work of the tribunal. I yes. had to, even before any party raised it.
No, of course. But your ladyship, in none of those matters, I would assume, were the applications to stay those proceedings pending the outcome of the Constitutional Court judgment.
In CMI there was. In CMI there was, and I made it very clear to the parties I was not inclined to order a stay. In fact, I had ordered, as I've indicated, the SIU to bring a formal stay application so that yes. I can deal with the request judiciously. And yes. it didn't work out that way.
Well,
I wasn't the presiding judge in the end.
We take note of that, my lady, but the fact is that in this matter, there is this application before your ladyship, and your ladyship must decide on this issue. Yes. So, and there's nothing untoward. All I'm saying, my lady, is my learned friend seems to indicate or imply to your ladyship that one can never await a judgment in another court before you continue with your proceedings or the work of the tribunal. In some instances, it is necessary. If parties, for example, in normal litigation, know that there's a pending case before the SCA or before the Constitutional Court that will have a material impact on the legal position and which will then have a material impact on their case, I mean, why would they not be entitled then to ask for a stay of those proceedings pending the outcome of, because it will be a waste of resources, it will be a waste of money, it will be a waste of time to proceed where the question will be answered by another court or by a superior court. So I submit, my lady, that there's nothing untoward about the procedure that was followed in this case. The second issue is the issue of the abuse of the process. I've addressed your ladyship on that, my lady. I submit that there is no abuse of the process in this case. The fact that the applicants elected not to or to take this to launch this application and to only answer on the merits in the main application main proceedings before the tribunal, that in itself cannot constitute an abuse of the process of the court. They will have to answer on the merits at some stage, my lady, and they will. And I don't understand the argument that that in itself constitutes an abuse of the process. The interests of justice, my lady, I submit, requires the tribunal to stay the proceedings. There is no, my learned friend referred to prejudice by the for the SIU, and the fact that there's no prejudice to the applicants. There is, of course, prejudice to the applicants if the rule is confirmed, because, my lady, if the Constitutional Court grants an order that is in favor of the applicants in the stay application, then they will not have the right to, or the opportunity to argue and rely on that Constitutional Court judgment when the confirmation of the rule is argued. And that is all that they're asking. They're asking for that opportunity if the Constitutional Court finds the way that they think the Constitutional Court will find. And for those reasons, my lady, we submit that the interests of justice will be served if the application is stayed. It may or may not have an impact on other matters. I can't speculate on that. Each matter will have to decide on its own whether they want to raise this issue. But in our matter, my lady, I submit that the proper case was made out and proper reasons were advanced. And for that reason, we submit that the order should be granted in the notice of motion in the stay application. I think my learned friend is correct that we've now limited ourselves to the judgment in the LEBELO matter, because the other matter, it seems, is also then will not be heard soon, because that is also stayed, as your ladyship quite correctly pointed out. So the LEBELO matter is the one that we're asking the court.
The other matter is not a stay. A stay was granted by agreement before the tribunal.
No, I'm sorry.
Powers are being challenged there.
Yes, I'm saying, sorry, my lady, maybe I misspoke. I'm saying that that application is, as a fact, now also stayed, whether it's by agreement or...
I see.
Yes. And for that reason, we're only asking for the judgment in the LEBELO matter, that it be stayed until that judgment is granted. And that costs be cost in the application, my lady.
Yes, the preservation order currently in the form of a rule NASA,
Yes.
if confirmed, will only be interim in nature.
Yes. It will be interim, but we won't be able to attack it even if
you can't at that point.
Sorry,
it will only be it's only interim in nature.
Yes.
Pending last week's application.
That is correct, my lady. But we say that the respondents aren't entitled to a confirmation of the rule, and we say that on the basis of what we expect, or what the applicants expect, the Constitutional Court will say in the LEBELO matter. If the LEBELO matter or the judgment in the LEBELO matter is that the tribunal does not have certain powers, then it will be argued that the tribunal should not confirm the rule. And that is why the application for a stay is brought, because it may have a material impact on the confirmation of the rule. And that's why we say your ladyship cannot grant or shouldn't grant confirmation of the rule at this stage. As a court, please, my lady.
Anything further?
No, my lady.
Okay, thank you very much for your assistance. I've greatly benefited from the excellent manner in which you've prepared the papers, as well as your articulate heads of argument. I will not take long with this judgment. At most 2 weeks, I will hand it down. So at this point, the proceedings have come to an end. We may commence with the case management meeting in respect of last week's application. I had not you know, normally parties would come having discussed